The broadcast is now starting. All attendees are in listen-only mode.
All right. Well, hello, everybody. Happy Wednesday night, and welcome back again to Webinar Wednesday. And tonight we're going to talk about the Americans with Disabilities Act and website accessibility. All right. For those of you who don't know me, my name is Dr. David Wank. I'm a practicing general dentist in New York City, and I am the president of Short Hills Design, which is an internet marketing company for dentists and for physicians. So let's go over tonight's presentation. It'll probably take about 35 minutes, not the usual 45. So we're first going to do this brief introduction. We're then going to give you some background information just about the law and where it stands right now. Then we're going to talk about why businesses are getting sued, or more accurately, why they're getting demand letters. Then we'll touch upon the current standards and what you can do. Then we'll take some time for questions. And then I have some resources for you. And then we can wrap it up. And obviously, I will stick around for questions after if you have them. And so let's get started. So introduction. So first, let me just say, from a point of fairness, I'm not an attorney. I'm a dentist and an entrepreneur. So I cannot give you legal advice. The area where I got this information from is I have read and read and read. I've dug into the Federal Register. I've tried to read. You know what? You'd be surprised. I'm a fairly well-educated person, and it was incredibly difficult to dig through the Federal Register to actually find just to get an idea of some standards, or to actually make heads or tails of what the government does or doesn't want us to do. And so these are my personal opinions and the interpretations of what I have read. And obviously, this is not a substitute for legal advice. I hate to have to say that. But again, I'm not an attorney. I don't have time to go to law school. And I'm happy where I am now. So with that being said, you really don't need any computer knowledge for this, basic knowledge, but this is more about of understanding where you are. The recording will be available a few days after the presentation. If you want a copy of these slides, send me an email and I will get you a copy of the slides. Questions. So in GoToWebinar, you can use the raise your hand feature to let me know if you have a question, and I will see it on my screen. I want to keep the time at 30 minutes, and I will stay longer to answer questions. We do have the time at the end for questions. Obviously, if someone asks a question that is in the middle of what we're saying and it's highly relevant, I will stop to answer it. But if I don't, it's not because I don't want to answer it. I just want to, people want to get out of here. Even though I just started, I understand. Okay, so the take-home message for this webinar tonight is to make your website as compliant as possible. And, and as you'll learn tonight in the next half hour, full compliance is not possible. And that sounds strange, but it's not. So that's the take-home message. You want to be as compliant as possible. So this goes, we always have our web design workflow that I talk about every webinar because it's that important. And those of you who have worked with me know I'm very, very adamant about this process, where phase 1 is our foundation, our development. Phase 2 is development of our website. Phase 2 is where we drive traffic to our website. Phase 3 is where we do conversion optimization, where we're actually saying, hey, I've got people, I've got traffic. What am I going to do with it? So phase 1, foundation, building a website to Google standards. Phase 2, how am I going to drive traffic to my website? What are we going to do to get people there? And then phase 3, once we're there, how are we going to turn them into new patients? And then phase 4, of course, is maintenance and backups. Please make backups. Free advertisement from me today. Please, please, please make sure your website's backed up and that you yourself own a copy. I've been dealing with 2 clients now who are coming from other vendors, and I won't mention their names. Those vendors will not make those backups available, even though they told the client they own, the client owns the website. And to me, that's abominable. Anybody who's worked with me knows, they own all of their stuff. And I think that's really the way that all of us have to go, whether you work with me or not. So what is the ADA? Let's start with that. So the ADA is the Americans with Disabilities Act. And what it is it was really aimed at making sure that people with disabilities have the same level of access to public places as do people without disabilities. And when we think about that, in our daily lives, we think about a handicapped bathroom. We think about wheelchair accessibility. We think about having a ramp. Those are all sorts of things that we think about for the physical aspects of, of a physical disability. And that's, or where you have at an ATM, you have braille at an ATM, or you have a headphone jack. So if you are hearing impaired, you can plug in that headphone jack and you can, hear it on a louder volume. So it's basically legislation that's designed to make sure that people who have disabilities have the same ability to access things as the rest of us. So it's a pretty complicated law, and obviously you can look back here. I can get you these links. Here is the the U.S. code, which is if you think that our PROS textbook is a mess, if you think that the RPD, I think I have a big thick RPD textbook. If I think that book's a mess, let me tell you, this is a mess. So the ADA has a number of titles 1 to 5. And Title 3 is the public accommodations title. There are all sorts of other titles in there, but Title 3 is public accommodations, and that's what we're concerned with here. Now, there's a separate act. So we've got the ADA, Title 3, public accommodations. That's us. And then you've got Section 508 of something called the Rehabilitation Act of 1973, and that's not the ADA. But that requires that federal agencies, and right here, E205.4, the accessibility standard, that electronic content shall conform to level A and level AA success criteria and conformance requirements in the WCAG 2.0. Now, this all sounds like gobbledygook, and we'll explain it all as we move ahead, but suffice it to say that Title 3 of the ADA is public accommodations, and the Rehabilitation Act, when they say 508, Section 508, that's what they're talking about. And that basically said, hey, federal government, if you're a federal agency, you have to conform to this level A and this level AA of accessibility. And we're going to discuss what that means. So then we had some changes. So in January of 2017, the government basically updated, right? We had here 1973, Section 508 of the Rehabilitation Act. The government updated it. So the updated section, so it's covered by Section 508 of the Rehabilitation Act and Section 255 of the Communication Act. And what happens is, I know this is ridiculous. So you've got the ADA, Title 3 public accommodations. Then you've got Section 508 of the Rehabilitation Act and Section 255 of the Communication Act. You've got three things. So Section 508 apply to electronic and information technology, and 255 address things like telecommunication. So if you're making telephones and things like that. So basically what happens here is that the United States has these guidelines all over the place. And as it says down here, it reorganizes 508 and 255 guidelines to catch up. And so what that also does is it also said, we want to talk here about the Web Content Accessibility Guidelines, WCAG. And if you notice here, it's a globally recognized voluntary consensus standard for web content. That's what this is. So the WACG is the Web Content Accessibility Guidelines, and they are voluntarily standards for web content. So where we are now is you've got the ADA, Title 3, public accommodations, bathrooms for handicapped people, and you've got ramps and things like that, and braille, and okay. That is Title 3 of the ADA. What you've also got is the Section 508 and the Section 255 of these other acts. And basically what this has come together to say is that, listen, we need to make websites more accessible. And there's something, and they said, hey, there's something out there called the Web Content Accessibility Guidelines, made up by these volunteers, and it is, an internet standard. So maybe what we should start doing is saying, hey, this is a good standard, and we're going to make the federal websites comply with these standards. So that's where this is going. The federal government has said, and I'm going to show you that the WCAG has 3 levels, A, AA, and AAA. And the federal government has said, what I meant here is, the federal government has to meet level A and level AA to be compliant. And the WCAG 2.0 is version 2 of it. We'll talk about that. So why are businesses getting sued or getting demand letters? There are articles that I'll reference. In the references here, a client of ours just sent me another article from the ADA. What's going on? So here's what's happening. The ADA does have an excellent resource that you should read. It's a PDF that talks about accessibility claims. It doesn't really give many answers. It gives general specifics, but it doesn't. There is no answer to this problem. But here's what happens. So you have a client, you have a person who we'll go with the most recent case. The most recent case was someone who was visually impaired who sued 90 other companies, and he sued Winn-Dixie supermarket about accessibility. And a lawyer presented, so that's a person, and they contact the lawyer. So what happens is a lawyer will send a demand letter to a dentist on behalf of a client. So let's say, unfortunately, someone can't access your website because they're visually impaired. All right. They contact a lawyer. The lawyer contacts you and says, hey, Dr. Smith, we've looked at your website, and here's a list of the accessibility problems that are found on your website, and you need to pay me these legal fees and fix the website, or we're going to take you to court. Now, because it's less expensive to pay the fees in the demand letter versus risk having to go to court, many businesses say, okay, you know what, I'll just pay you. So let's talk about that again, and that's what's really happening here. And I think the ADA in that guide calls them drive-by lawsuits. So a lawyer usually runs an automated scanner of a website that can see, that can tell you what's wrong with it from the perspective of the web standards of 2.0, WCAG, which we'll talk about. And then, of course, that computer program is going to return a bunch of standards and say, this is wrong, that's wrong. And then I'm not going to say they solicit clients, but suffice it to say, if a client who's visually impaired finds an attorney and says, hey, we can't access Dr. Jones's website, well, then Dr. Jones, then they send a demand letter. You run the scan against Dr. Jones's website. Say, hey, Dr. Jones, yeah, listen, here's a demand letter. My client, would love to come see you as a dentist, but your website does not meet accessibility standards. And here's a printout of the standards it doesn't meet. And so therefore my client can't use your website. So it costs me, thousands of dollars to talk to him and do all this stuff. So this and all this paperwork. So I need you to pay me legal fees and fix the website so my client can access it. Otherwise, I'm going to sue you. And that's really where this stands. And so why is this terrible? This is terrible. Well, obviously you want every patient to be able to access your website. But the problem is that the current standards are recommendations. They are not definitive standards. There is no do this and you'll be fine checklist. That's the problem. Even something as, an open margin on a crown. I mean, you and I all know from clinical practice what's an open margin and what's not an open margin. And look, I saw a crown today, and I got to tell you, I said to the patient, listen, this margin is really close. And probably in the next year or two, we'll replace the crown. The film was fine. There's no decay. But, the ADA has a standard of how many microns, you can get in, the tine of an Explorer. So at least that's a standard. At least, now you and I can argue, where we are on the microns, but at least there's a standard. And the problem here is that there is no checklist. There's no list that says, dear Dr. Smith, Dr. Jones, Dr. Smith, who got this demand letter, Dr. Smith can't just say, okay, you know what? Let me go on the web. I'll print out this list. And here are the ones that if I check off every box here, then I am going to be safe. And the answer is that doesn't exist. And that, to me, as a business owner and as a dentist, that's not fair. And so the DOJ is supposed to issue specific rules in 2018. I read somewhere that the Trump administration, not being political, like it or not, the Trump administration said that allegedly, in order to ease the burden of regulations, they're not going to deal with this issue. I don't know if that's true or not. And that obviously is, neither here nor there. That's, I'll keep you up to date if I hear something, but that's what I have heard. Now, here's the bigger problem. Now, let's say you said to that attorney, you know what? I'm not paying your fees. You can stick it up your nose because this patient who is visually impaired, if your client would like to call me in my office, I will, spend the entire day on the phone with them and read them the website. I think that's fair. But does the law say that's fair, or do the standards say that that's fair? And the answer is we don't know. And so the courts are split over whether a website or a mobile app is a place of public accommodation. So you could bring it to a court, and the court's going to say, yes, your website is a site of public accommodation, just like your office is. It has to be accessible for wheelchairs and, and handicap parking and those sort of things. Or the court could say, no, it's an app. And so it's not a public accommodation, and the courts have not decided that. They also haven't defined what constitutes an acceptable alternative. And that's also very frustrating. So if this person who is visually impaired would come to the office, you could certainly say, Mr. Smith, I understand you're visually impaired. If you can get to the office, we'll send a car for you to come to the office, hypothetically, and we will explain everything to you. And we will get the website translated into Braille for you and mail it to you, whatever. And I think that would be fine. I think it'd be very kind. If you translated your site into Braille or whatever you happen to do, is that enough? So when this lawyer says to you, Dr. Smith, Dr. Jones, you are, my visually impaired person cannot access your website, you say, well, look, I have the whole website printed out in Braille and I update it once a month in Braille. It's pretty nice. I will send a car to bring him here to our office. We'll go over it with him. Any questions he or she has face to face. Is that okay? And the answer is, I don't know. He could still bring you to court. He could still say, yeah, you know what? That's not good enough, because the standards say that you have to have certain voiceover or certain X, Y, and Z to be accessible, and that's the frustrating part. So, and these are ambiguities in the law, and lawyers are taking advantage of it. And it's really, again, I keep saying it's bad, it's not fair. It's really not, because I'm all for the law, and I'm all for, we have a professional responsibility to treat patients well and to be ethical in our duties. Look, as people and as a community and as dentists, I can't tell you how many dentists I know have given for Hurricane Harvey and Hurricane Irene aid, Hurricane Harvey and Hurricane Irma aid. I have. And to say that, to just come after people and other businesses, not just us, lawyers are going after lawyers. I'm sure that doesn't surprise you, but that's what's happening here. And so that's why I have this tone of frustration, because it really is between a rock and a hard place. So let's say you said, you know what, Mr. Lawyer, sir, I do not want, we're not paying. What do? We go to court, and you can say, look, I can't be held liable for not adhering to a standard because a standard doesn't exist. If you said to me, you say, okay, Mr. Attorney, please print out where it says in the statute, is there statutory language that says this is what I have to have? And the answer is no. So will a judge say, Dr. Jones, you're right. There's no statutory language, so you are free. You're off the hook. Yeah, and how many tens of thousands of dollars later did it cost you in legal fees that you're not going to recover to do that? So some of the recommendations that I'm going to show you later are judgment calls. And so some things, you can't quantify as a pass-fail. If you see, today I was looking at a film, I did a recall today, the distal of whatever it was, 20 has a crown, there's recurrent decay, it's pretty clear. It's a pass-fail, that's decay. But yeah, there are other teeth I saw today that are judgment calls. And you can't, as we know, especially in dentistry, there's a lot of judgment calls. In medicine, there are a lot of judgment calls. And you can say to the judge, let's say, Judge, some of these recommendations are judgment calls. So how can you hold me to a standard that's ambiguous and that doesn't really have a correct right or wrong? You can never, ever be held to that standard. You and I can both look at an RPD and say, maybe my receipts are deeper than yours, or your receipts are deeper than mine. Yours are 1.5, mine are 1.8, or mine are 1.2, which is maybe a little shallow. But look, we can both tell you the RPD fits. But there's no wiggle room in this position, which again is frustrating. Plus, the other thing you can say is that the cost to bear to implement the recommendations are prohibitive. As I'm going to show you, some of these recommendations require human testing, which I don't mean like human experimentation. I mean, humans have to test it, which again, the cost of that is prohibitive. I have friends of mine from dental school who have two lives. Their first life is as a specialist, as an endodontist, let's say, and they practice 2 days a week and do well. And the rest of the time they're at home or they're doing something else, running a business or being with their family. And compare that to a dentist who runs, a $2 million office. The $2 million office person probably has a larger budget for marketing and for this kind of stuff than the person who works 2 days a week, yet they're held to the same standard. And so claim the costs that you have to pay. Your Honor, it would bankrupt me, or, this is more than I spend in marketing a year to fully implement the recommendations. So even though these are viable arguments, and I think they are, And a lot of these came out of the ADA article, the ADA publication I showed in the beginning. It takes way too much time and money to make your case. And that's where this paradox is. So what are the current recommendations? So there's something called WCAG 2.0, and those are the Web Content Accessibility Guidelines version 2. Yes, there was a version 1, but now it's WCAG 2.0. And so what this is there's something called the W3, which is the World Wide Web Consortium. And these are the people who, you ever heard someone say that, is your HTML valid or is the CSS valid? If that's not English, don't worry. But there's a group over the years that came together and said, hey, we need to standardize web languages. We need to standardize it so that if you're using iOS on an Apple device, or if you're using Android, that you have the same web experience. If you remember years ago, if you went on Internet Explorer, the website looked different than if you went on Safari or on Chrome. So part of what this group did is said, let's make standards to make the web better. And there's nothing wrong with that. And so they came out with these accessibility guidelines, and they said, hey, if you want to be accessible for people with disabilities, here's a recommended list of 39 checks with 120 rules. And there are 3 levels of accessibility. There's A, AA, and AAA. And you can look at them here. They are overwhelming, the list there. And so it goes by principles, guidelines, and rules. Now, here's a summary of the principles. So we'll start from the top. We're not going to go through all these, don't worry. But suffice it to say, this web consortium, which is a international respected group of experts who make recommendations of how to make the web better. And obviously, when someone said, hey, you know what, Flash doesn't really work that well on mobile devices and this and that, they worked with Microsoft and Apple and Adobe and said, let's get rid of Flash. Different ways to do it. Great. But these guys also did the accessibility standards, and we grouped them into 3 groups: the principles, the guidelines, and the rules. So here are the principles. Principle number 1 is perceivable, which means that you can see it, you can access it. Operable, which means it's usable. Understandable, which means obviously it's understandable. And I got to tell you, and 4 is robust, maximizing compatibility. Now, if you look over here, which I understand here, help users avoid and correct mistakes. I mean, I can't begin to tell you how upsetting that is to me, because as dentists, we know every day how many times I have patients who come for partial adjustments and forget their partials. So all right. So perceivable, operable, understandable, and robust. And so under these principles, you've got guidelines. And so let's take a look at a guideline. Provide text alternative for any non-text content, so it can be changed into other forms people need. And that's great. That makes a lot of sense, and that's easy. We all know that as alt tags. Any of you have worked with me or have been to one of my webinars know I'm big on alt tags. And what an alt tag is, it was designed for years and years ago when people turned off their images to make web pages load more quickly. And what alt tags do is they describe the image. So if you have a veneers page, a picture of veneer, you'd write, the alt tag is picture of veneer or veneer. So alternative for time-based media. It gets into detail about what that means, but that's kind of abstract. Create content that can be presented in different ways without losing structure. Again, very abstract. So, the first one's easy, but make it easier for users to see and hear content, including separating foreground from background. Again, that's kind of ambiguous. So let's just look for a second here. So this is 1.1, providing text alternatives. Let's just take a look, because here are, remember we said there's principles, guidelines, and rules. There's the principles, 1 to 4. Here's a zoom in of the guidelines. And let's zoom in again to the rules. So here, principle 1 we said was perceivable. Guideline 1.1 is text alternative. So if you look here under non-text content, has to have a text alternative. And so here we go, time-based media. Test if, here we go. So here's how you actually test it, which is just a mess. If non-text content is a control or accepts user input, has a name that describes it. So that means that your forms, you have a form, and we usually do this with your contact form, name, last, first, email. Certainly that's easy to do, to name that content. But time-based media, well, there are more requirements. Here you go. If non-text content is a test or exercise that's invalid. So what I'm trying to show you is some of these are really easy. Here's the best one on this page. If non-text content is pure decoration or used for formatting, or is not presented to users, it's in a way that can be ignored by assistive technology. So are you going to go through your website or pay me or pay someone to go through your website, determine what's pure decoration? How are you and I going to decide that? And it's used only for visual formatting or is not presented to users. So, how do you even meet that standard? So what they do here, and again, so this is how to meet them. And if you have here, this is how you actually understand them. So, sorry, it goes here to the principle, the guidelines, and it has how to understand the guidelines. On the top right here, understanding the guidelines. Then here, it talks about, meeting the guidelines. And again, looking in here, this is what we talked about. So here, if non-text content is primarily intended to create a specific sensory experience, then text alternative should provide a description. So, performance of a flute solo, works of visual art. Okay, well, is an example of you adjusting a denture, is that a sensory experience? Or an example of you, showing people that the noises in your office are not bad noises, they're okay noises? Is that a specific sensory experience? So again, this is where the ambiguity becomes frustrating. And so let's look again, primarily intended. Even if we agree on a specific sensory experience, what that means, if you're in court, again, pressed with this demand letter, how can you and I argue what the primary intention? How can an attorney know what my primary intention is when you and I built your website or when you built your website? And are we going to have to prove somehow our primary intention? So without worrying about what all that means, and again, that is really getting really deep in the weeds, and I don't like going there myself. That's why I want you to understand why it's not that easy. A client of ours sent me an article, as I said, that talked about, well, what you should do is you should find a web development firm that puts in there a contract, that puts in their web agreement, they will meet these web standards. And I got to tell you, at this point, I would never put that in my web agreement as a company because it's not possible. It's totally impossible to do that. And I might have to send the ADA a letter because I don't think that and if a web developer does guarantee you that, I'm going to raise a really big eyebrow because, again, at this point, there are no rules. There's no statutory rule. It's just a recommendation that happens to be well loopholed enough for attorneys to come after you. But again, just think about this. If the web company is going to say to you, listen, we guarantee you that you have, that you'll be compatible. Well, then I would get it in writing too, that it says that if you get sued, that they're going to, they'll pay the legal fees or, or whatever that's going to be, or ask them how they're going to define primary intent and prove later on that that's what you intended, or ask them what a specific sensory experience is. And they probably won't be able to answer. So I might have to write a letter to the ADA. Now, so what can you do? Not much. And the answer really is to go ahead and to make yourself as small a target as possible. There is no way to meet all of these standards. And even if I did, even if you came to me with, or with a suitcase of cash and said, here's an unlimited budget, make this pass the test, I can make it pass probably all the automated tests, but could I guarantee, and you said to me, David, guarantee, here's a suitcase full of cash, guarantee me that if someone sends a demand letter, I'll definitely win if that has to go to court. And I can't, because what's primary intent? What is a specific sensory experience? There's an example. But again, does not primarily convey important or perform a function. How do you define that? So you could give me all the money in the world, and I'd be happy to take it, but I still can't guarantee you that an attorney is not going to come after you for that, right or wrong. So my approach to this is to minimize your footprint and make yourself a smaller target. And that's really all that you can do. You can certainly run your site through an accessibility checker. Here are two of them here. You're going to be surprised what you find because the minutia of this is so ridiculous that it's not fair to say ridiculous It's not ridiculous to somebody who has a disability that makes the website hard for them to get to. It is ridiculous as from a burden perspective, from a business, where what can we do to run a business and still make accommodations for our patients who need our help? And I think that what you should do at a minimum, if you want, is put your site through an accessibility checker. And you do want to aim for level AA. The reason I say that is because, yes, the federal government said that. But in the recent case of where Winn-Dixie, I mentioned earlier, where the supermarket was sued and lost, the judge told them that they had to bring their website up to AA standards. Now, they lost because you could do online shopping. And the argument was that because that this person who was visually impaired couldn't use the website to do his online shopping like everyone else could, then that was the crux of this issue. But I would aim for level AA at a minimum. And I don't know if it will help or not, but it certainly can't hurt to put an accessibility page on there that says, we understand that, everybody has different accessibility needs. Please feel free to call our office at this number, and we can arrange, whatever you need kind of thing. And so that way, at least, again, I don't know if that will protect you, but at least it shows that you'll make an effort. At least that way, if you have someone who's truly hearing impaired, maybe they will read that and it says, listen, if you need, look, I've got a client who calls us over TTY, a patient. So, that's how we accommodate him and the other people. So certainly, I think if you're right, we're happy to, teach TTY to get in touch with you. We are happy to read anything to you or print, I think if you make a good faith effort to show that you are at least taking it into consideration, I'm hoping that the lawyers will kind of find someone. It's kind of like many years ago when we had the club, where you put the club on your wheel in the parking lot, and the idea was that you can't saw through the club. They can certainly still steal your car, but at least if you have a club on it, it'll take them a few minutes longer for someone to steal your car than a car that doesn't have the club. So I would hope that even doing something like an accessibility page would, with some generic text that sounds personal, would at least help kind of maybe reduce your footprint and maybe make you a smaller target because you've at least tried to make somewhat of an effort. And again, but if you're going to move forward, aim for level AA. Now, what you can do here's another checker you can look at to test level A. And here's what you'd want to check. You'd want to check level 2, level AA. Don't even look at level 3. It'll give you a headache. And here are the references and here are the resources. What I will tell you is that I would make an effort, and what we're doing now in terms of for moving forward, because I thought about this the entire summer, about the best way to handle this for our clients. Because the truth is, what you've got to do, and again, whether you work with me or anybody else to help you with this issue, what you've got to do, number one, is you have to look at a list of standards and decide with your web person, and decide by yourself or with me. I am in the next few weeks going to make a checklist that I think is decent, but to say, listen, how can we balance a practical approach with affordability? Because if someone's going to charge you $5,000 to get your website pretty close to accessible, and you could still get a demand letter, and it's annoying. If all we do on your website is fix those title tags, the alt tags, and we spend, $300 doing that, will that put you in a better position? How much better off or worse off would you be if you spent $5,000 and did everything except only the most challenging things to do? I don't know. And so I think it makes sense to try and catch the low-hanging fruit to meet the easy standards. And once you've met the easy standards, I think that's where it has to be for right now. I'm hoping in 2018 the government will give us a checklist. Say, this is what we have to do. I'm not going to rely on that, but I think that's going to be the approach. So I would say, number one, put an accessibility page on your website just to show that you are conceding that it's an issue and that you as an office will make an effort. Number one, at least you can always say, hey, we have an accessibility page. We said that we're going to try and help. Number two, you can certainly run your site through a checker to check. Or number three, you can talk to me or your developer or look at the guidelines on your own and say, look, what if this makes sense to me? And for those that make sense, it might make sense, no pun intended, to put those in place. Because again, you could spend, we've got to look at the entire website, look at the standards we're going to pick, look at the entire website and fix it. And that's where it becomes It just takes time. It's not one of those things. If you have a 60-page website, or even images, if you have for alt tags, if you have a website, we just put out a website. It's about 60 pages for a dentist with a ton of, with 45 images. If you've got 45 images, it's going to take us longer to resize them than a site with 12. So again, this probably gave you more questions to ask. I hope it gave you some answers. Here are, and I can send you this if you'd like. You're asking for the slides. Here are the references, and here are some more. And again, I know you can't read them that quickly, but I will get them to you if you'd like. And then next month, what we're doing is PageSpeed Insights. One of the big things that we have to do for in phase 2 in driving traffic and getting your website ranked in search engines is PageSpeed. And I've talked about it before. If you and I have the exact same web page, not exact, but you know what I mean. Practically speaking, we both have really great pages about bone grafting, and your page takes 12 seconds to load, and my page takes 3 seconds to load. I'm going to win. And I would rank higher. If my page ranked at, took 3.1 seconds to load and yours took 3.4, probably no difference. So we're going to talk about, page speed. And again, it's one of those cost benefits. There are things that you can do that will cost you an obscene amount of money to speed up your page that are probably not worth it. But there are easy things to do that, again, are low hanging fruit. A lot of my clients, because again, our clients do have access to their WordPress websites. We encourage them to update them when they can. They will upload an image that's, a meg or 2 megs, which is a huge image for the web. We want them to be 100 kilobytes or 50 kilobytes. And so a megabyte is 1,000 kilobytes. So if we want an image that's 50 kilobytes, and the client will upload an image that's 2,000 kilobytes. And so very, very quickly, that makes a page load a lot more slowly. And then after that, we're going to talk about marketing automation and lead generation. I have a few new marketing programs that we're doing, because once you've built your website to standards, once you have done SEO, you've brought your website up to, with the appropriate keywords, even if you're doing pay-per-click, which is not right for everybody, in competitive areas, it becomes a fortune. The next thing you're going to probably want to do is figure out how to generate more leads. And one of the things that I'm doing now is I have something I'm launching towards the middle of the fourth quarter. It's going to be our innovation suite of products. And the innovation suite is basically going to be lead generation for specific services. If you want to do Invisalign, if you want to do dental implants, whitening, whatever it is, we are generating service-specific programs. And if anybody wants to talk more about those are in pilot right now, so the fees are heavily discounted. I don't know if they're going to work, hence the fees are low, and it's a pilot program. We've definitely had clients schedule appointments with it, so it's great. But again, something to mention. And please, if you haven't already, please join our Facebook group. We get a lot of good insight on there. And somebody asked me here, is there any insurance that covers a lawsuit coming out of web accessibility, like business insurance or some kind of special insurance? That is a fabulous question. I don't know the answer to that. And I would guess to say the answer is no. Because again, I don't know how you can be compliant to a certain set of standards. At least like HIPAA. If you look at HIPAA, you really can't be HIPAA compliant. I mean, yes, I can be, but is there a checklist? Is there a checklist that says somewhere what makes you HIPAA compliant? When you get audited, but there's no checklist you can check off and hand that auditor and say that. And someone asked, can we ask the ADA to set a standard for us? Sure. Meaning the American Dental Association. Yes, but A, they probably won't. But B, they can't. Because the ADA can set all the standards that they want. But at the end of the day, the federal government and this federal judge said, listen, we're basing this on the WCAG2, the Web Content Accessibility Guidelines. And so, the question, who's the ADA going to lobby? Right? That's the question. The ADA can lobby the government and say, hey, please, say to us, what standards? And that's also a concern that I have. What happens if I say to you, hey, I want to bring your website up to standards, and you hand me that suitcase full of cash? Let's just say you do. You hand me the suitcase full of cash, and we get basically most of it out there. There's still a couple of open things that aren't practical to do because they require human testing, so we don't do those. And then the next day, the government says, you know what? We took a look at the guidelines, and all we want you to do really for 2018 is to make sure that you have alt tags. And you just dropped $5,000 with me for doing all this accessibility work that may or may not be required in the future. It's kind of like when Google switched to being responsive. We had said for years, be responsive, be responsive, be responsive. And, it was a recommendation. But once Google said, hey, you've got to be responsive, what they did is Google was kind enough to put a test out there. So you could actually go, and we've done it. You go to, do a Google search for it, and you can actually look and see if your website is mobile friendly. And it basically says to you, yes or no. And I wish, because that's a great question, that there was something like that could say to you, yes or no. But again, because there's such a long list of things that no matter what you do, you're not going to be able to meet those accessibility guidelines because, again, it's not possible, unfortunately. So what I will tell you then in summary is make an accessibility page for your site that just shows in good faith that you're making an effort. Have someone take a look if you want to go ahead and do some of the low-hanging fruit. Please, if someone does send you a demand letter and you want to reply, again, I don't know if that's a good idea or not. You can at least say, hey, look, we've done X, Y, and Z. Go bother somebody else. And that was one, and that was two. And three, if someone's going to tell you that they're going to make your site ADA, compliant, I would, raise an eyebrow at that. I would be very cautious. There is a web group out there that says they are doing that. And again, I wish I could say that, but I can't because it's not possible. So that's something I would definitely bring up. And last but not least, there is my contact information. And that is it. So are there any more questions? All right. Well, if there are no more questions, that is that. If you want the slides, feel free to email me or fill out a contact request on the website. And I hope you found this interesting and have a wonderful evening. And thank you again for taking the time and coming.